Hi, welcome. Mark Satawa, principal attorney at Satawa Law, and today's video blog is on Shaken Baby. Specifically, are we finally seeing the end of the long Shaken Baby nightmare? The answer is a definite maybe. In a previous video blog, we discussed the ABCs of shaken baby syndrome or abusive head trauma and some of the false assumptions that are necessary and at the heart of this very controversial and disturbing diagnosis. Folks, the simple fact of the matter is that shaken baby syndrome is junk, the purest, most base of junk. It's not science. And it's becoming more and more criticized in courts throughout the country. As recently as August of 2019, a Massachusetts judge has reversed the murder conviction of a nanny that was charged and convicted under traditional shaken baby syndrome evidence. The judge, in his opinion of reversing the second-degree murder conviction of this nanny, went on to recognize the current debate and series of criticisms that shaken baby syndrome evidence and abusive head trauma has started to really suffer from throughout the United States. Here in Michigan, we have really started to get with the program. There are other Western civilizations, Great Britain, Japan, that have already outlawed the use of shaken baby syndrome as being inadmissible in court to prove that a child has been abused. In Michigan, we hopefully are seeing the first initial baby steps towards that goal. And at that point, our long nightmare of with shaken baby syndrome would finally be over. In 2015, the Michigan Supreme Court, in a decision called People v. Ackley, landmark decision, ruled that the failure of the trial lawyer in that case to use and consult with and hire experts was ineffective assistance of counsel. The interesting and important thing about that decision was that the lawyer in that case did actually consult with an expert. They just didn't consult with the right expert. The expert he consulted with said, hey, you realize I'm a prosecutor's expert. I believe in this stuff. You may want to talk to somebody else. In making that decision, the Michigan Supreme Court noted in their opinion that given the centrality of expert testimony to the prosecution's proofs and that failure of counsel to consult with an expert who could meaningfully assist him in the defense of this case constituted ineffective assistance of counsel. The really interesting part of that case, however, was that in what we lawyers call dicta, which is kind of like extra language that the court isn't necessary to the court's decision, but where the court and the Supreme Court in any state, in this case Michigan, can kind of send a signal to lower courts and to litigants. It's called dicta. It's kind of extra language where the court can show, hey, this is the direction we're heading. This is what maybe we're thinking about a particular topic as you go forward. In dicta, the Michigan Supreme Court said, in addition to given the centrality of expert testimony to the prosecution's proofs, they went on to say, and the highly contested nature of the underlying medical issue. The highly contested nature of the underlying medical issue, of course, shaken baby syndrome, is strong evidence that the Michigan Supreme Court is really taking a long, hard look at this junk that the children's hospitals and child protective centers want to call science. And they are sending a strong message that, hey, look, folks, this stuff maybe not be all it's cracked up to be, and in fact, may not be around much longer. Recently, in just this year, in July of 2018, in a case of People v. Brown, the Michigan Court of Appeals, in following that Akeley decision by the Michigan Supreme Court, reversed the manslaughter conviction of an individual who was charged with manslaughter in connection to the death of his 5-month-old child using traditional abusive head trauma, shaken baby syndrome evidence. And again, the Michigan Court of Appeals in that case noted that failure to consult and hire even a single expert who could have presented the other side of this debate, who could have presented an alternative explanation for the injuries of this case, and cast some doubt on the prosecution experts who claimed that the child had to have been abused, the child was abused by shaken baby syndrome, and that the child, that the person who was the caretaker of the child when the child arrested, in this case Mr. Brown, had to have been the person that committed that abuse. Again, failure to consult with, hire, and present an expert in the defense of Mr. Brown, clear and effective assistance of counsel in the mind of the Court of Appeals. So what does this all mean for those of you who might be facing this awful charge of hurting your own child by shaking the child violently enough to cause subdural hematomas, retinal hemorrhaging, and edema? What it means is this: when you go and look for a lawyer, make sure your lawyer has a list, a catalog, a Rolodex of experts. These cases cannot, should not, and will not be done without expert assistance. You cannot go to trial when facing a shaken baby syndrome charge without the assistance of an expert. I repeat, you can't go to trial without the assistance of an expert. And if your lawyer doesn't have experts that he can go to or she can go to, does not have a Rolodex, a catalog of those experts, does not even know where to look for them, you got the wrong lawyer, okay? Again, these cases are specialized. There's so much science, biomechanics, in causation and the mechanism of injury. There's so much medicine, radiology, neurology, and in some cases even related to the birth of the child, where 70% of newborns, as high as 70% of newborns, have been diagnosed with subdurals. So much medicine, so much science, so much nuanced technology and complex proofs that you really, really want a person who not only knows these cases, but has a track record of doing these cases and doing these cases successfully. And in order to successfully do them, you simply need to use experts. Folks, I hope you enjoyed today's video blog. I am Mark Satawa, principal attorney at Satawa Law, and as always, we are defending your rights, protecting your future.